I'm going to issue spot another wills hypothetical in this one. But before I get started, I'm asking a favor of you. Please subscribe to the channel so that we can help the YouTube algorithm and get more people watching these videos. And also, if there's something besides issue spotting essay hypotheticals that you think would help in your bar preparation, please let me know. Add a comment and tell me what you would like to see. Do you want to see a Patreon channel with live chats? Do you want to see other kinds of content? What is it that you would like to see? Let's do a wills hypothetical with some different issues than the one we did before. The call says, what rights, if any, do Nell, Ann, Bob, Carol, and the START employees have in Ted's estate? When I see all these potential takers in the estate, and that list includes employees, START employees, I wonder if we're going to be presented with an issue of an act of independent legal significance, because these employees are not named, whereas the other potential takers are Nell, Ann, Bob, and Carol. But the START employees, that sounds like a list that's going to come from outside the will. So let's see if that's what we do have here. I know that it's not a trust's answer because it says answer according to California law. And California tests majority law in trusts. So in 2001, Ted, who is married to Wendy, signed a valid will bequeathing all of his property as follows: $10,000 of my separate property to my daughter Ann, then $2,000 of my separate property to each person who is an employee of my company, START, at the time of my death, and all the rest of my separate property, plus all of my share of our community property, to my beloved wife of 20 years, if she survives me. No other gifts were specified in the will. Okay. I always work my way through a wills hypothetical by figuring out at each time point what the instrument is that controls and who would take what. So in this one, they tell me it's a valid will. I'm not going to fight that fact. I'm not going to try to form a formally attested will or anything like that. I'm going to accept the fact that it's a valid will. I'm going to explain to the reader that California is a community property state and that a testator can will away all of his or her separate property and his or her share of the community property. The big issue in this one is that list of employees at the time of my death. That list is unknown when the will is written. And so in order to probate this, the court is going to have to admit an extrinsic document. There are two kinds of extrinsic documents that we can get admitted as part of a testamentary instrument. One is that we can incorporate a document already in existence by reference, but this one isn't already in existence, so I'm going to have to look to the other doctrine called acts of independent legal significance. And that doctrine says that the probate court will admit a document created after the will was executed, as long as that document is not an effort to get around the will's formalities. In other words, it has some independent legal purpose aside from probate. A list of employees, an employment list, would have such a purpose, so it would be admissible to the probate court. The other interesting provision in this will is the gift to his beloved wife of 20 years if she survives me. That's a conditional gift. So the anti-lapse statute is not going to apply if Wendy dies before the testator, and I suspect she will. There's no anti-lapse issue, because if she predeceases Ted, then under the terms of the will, she doesn't get a gift at all. And even if that condition hadn't been there, if she predeceases Ted, her gift would lapse into the residue of the estate, right? Because in order for the anti-lapse statute to save it, she would have to be blood kindred of T. She's not, she's his wife, or a relative of T's current or former spouse. She's not, she's his spouse. So regardless of whether the contingency was there or not, the gift would be gone if she dies. Okay, so the next thing we see is that Wendy does indeed die in 2003. And notice that contingency, if she survives me. She did not, so her gift is just gone. That gift is ineffective because she didn't meet the condition. Then what happens? In 2005, Ted adopted a child, Bob. This is an after-acquired child. California law treats adopted children exactly like biological children for the purposes of the probate code. That means that at this moment, Bob is an omitted child, and the issue would be, is he going to be entitled to an intestate share? Then we see that in 2006, Ted signed a valid codicil to his 2001 will, stating that I hereby bequeath $10,000 of my separate property to my beloved son, Bob. All the rest of my 2001 will remains the same. Okay, again, don't fight the facts. The issue here is not formation. They tell you it's a valid codicil. The big effect of a codicil is that it republishes the original will. So now the publication date of the will is 2006, and Bob is no longer an omitted child. So I'm going to cross that out. I might explain that in my answer if I have time, but the will is now republished in 2006, and there's a $10,000 gift of separate property to my beloved son, Bob. That means that in some sense, the testator has at least partially revoked other dispositions in the original will. The original will left $10,000 of separate property to daughter Anne, and then all the rest of the separate property plus his share of community property to his beloved wife of 20 years if she survives me. You could call that a partial revocation, but actually, since Wendy had already died, that would mean that that $10,000 gift is coming out of what would have been part of the residue of the estate. So in that sense, it decreases the residue of the estate and any gifts that would be given by intestate succession, because he has not specified what's to happen with the residue of the estate. In 2011, Ted married Nell. Now we have an omitted spouse. She is an after-acquired spouse, and unless something happens to republish the will again, she's going to be an omitted spouse, and again, the issue will be her intestate share as an omitted spouse. Right now, we have 2 children. The intestate share for an omitted spouse when there are 2 children is all of the decedent spouse's interest in the community plus 1/3 of the separate property, because there's more than one child. In 2012, Ted and Nell had a child, Carol. Now there are 3 children. There's daughter Ann, there's adopted child Bob, and now there's Carol, who is an omitted child. She's an afterborn child after the date of that codicil. In 2016, Ted died, leaving his 2001 will and his 2006 codicil as his only testamentary instruments. After all debts, taxes, and expenses had been paid, Ted's separate property was worth $90,000, and his share of the community property was worth $100,000. At death, Ted still owned Start, which by then had 10 employees, none of whom had been an employee of Start in 2001. Okay, we have some complications here that I have to tell you none of the high-scoring answers I saw from the bar dealt with. So let's take these things one at a time. Let's talk about Nell. First, I think Nell is going to take as an omitted spouse and not as the spouse under the 2001 will, because that was fairly specific. It said, my beloved wife of 20 years. Nell has not been married to him for 20 years. So she's going to take her share as an omitted spouse. And what that means is that she's going to get 1/3 of the separate property, and she's going to get Ted's interest in their community property. Now, the hypothetical was kind of vaguely written, so it does not say that at his death he left $100,000 worth of community property with Nell. In other words, was that their community together? Or was part of that the community he shared with his beloved wife of 20 years? We have to assume that it's the community with Nell, in which case Nell will get that $100,000, and she will also get 1/3 of the separate property. And here's where people get confused and go astray when you have an omitted spouse or omitted children. The way this works, and the California Probate Code is very specific about it, is that you ignore the fact that there's a testamentary instrument for the moment, because the omitted spouse and omitted child shares come out first. So act as if there was no testamentary instrument and Ted died intestate. And what would his estate have been? It would have included $90,000 in separate property. So Nell is entitled to 1/3 of that, or $30,000. The remaining 2/3 get shared among the children under intestacy. So Nell gets $100,000 in community property and $30,000 of the separate property. Who's next in the call? Ann. And I would do them in the order they are in the call, because that's what most people are going to do when they answer this. Ann is the daughter in the original will who was left a gift of $10,000 of separate property. So we give Ann that $10,000. What about Bob? Bob is the adopted child. He was an omitted child, but then there was the codicil. He's no longer omitted, and he's been left $10,000 in separate property. So he gets $10,000 in separate property. We've now whittled that separate property down somewhat. We have 30,000 and 10 and 10, so 30, 40, 50,000 of it gone. All right, who's next? Next is Carol. Carol is an omitted child. That means that Carol is going to get her intestate share of the separate property as if there had been no will. we said that when we were figuring Nell's share, that she would get 1/3 and the children would equally share in the other 2/3 if there were no will, which means an omitted child would get the omitted child's share out of that separate property, or 1/3 of the 2/3. 1/3 is 60,000, that's 20,000. So we're awarding $20,000 to Carol, the omitted child. We'll come back to this because under that scheme in the probate code, Carol, the omitted child, gets twice as much as either of the testator's children that he was aware of when he made out his testamentary instruments, which doesn't seem like the result the testator would have wanted, but that's how the statutory scheme goes. Okay, so now we have accounted for $70,000 of the separate property, right? 30 to the omitted spouse, 20 to the omitted child, and 10 as the gifts specified in the will to the other 2 children. Now what? Now we have the start employees. And under acts of independent legal significance, we're going to look at that employment list at the time of Ted's death. And it doesn't matter that these people were not employees at the time of the will, because the will specifically said employees at the time of my death. 10 employees each get $2,000 of separate property. That takes away another $20,000 in the separate property. And notice that whoever wrote this hypothetical gave you an estate that comes out exactly even. So there's 30 to Nell, 10 to Ann, 10 to Bob, 20 to Carol, and 20 to the start employees. That's $90,000. That's what he had in separate property. Ordinarily, I would talk about the fact that the probate code in this area allows the court some power to deviate if there is a result by statute that doesn't seem to match what the testator would have wanted. In other words, if under the omitted child or omitted spouse doctrine, the omitted child, the omitted spouse winds up taking an inordinate share of the estate compared to other gifts the testator wanted given. And that is the case in a way here, because the omitted child is getting twice what the 2 children who were specifically devised part of the separate property get under the testator's will. But the entire $90,000 is accounted for here. The discretion the probate court has is to deviate from the statutory scheme, decreasing all the gifts proportionately in order to make up some shortfall. But that's not really going to work here. So I think that in this instance, I'm not going to raise that. I'm simply going to summarize for the bar grader that Nell would get all of the community property and 1/3 of the separate property. Ann would get 10, Bob would get 10, Carol would get 20 as an omitted child, and the start employees would each get $2,000, meaning that all the separate property is accounted for by the will. There is no residue to distribute by intestate succession. This is a really good example of how doable wills hypotheticals are if you just stay calm and at each point figure out who would be getting what. It all will work out in the end. The most tricky parts of this are understanding how the omitted child, omitted spouse shares come out. That they have to come out first as if there were no will, and then we go back to the testamentary instrument. And of course, California's statutes on omitted spouse, omitted child, particularly the omitted child statute, is very specific about the conditions under which that omitted child will not be entitled to an intestate share. One of those exceptions to the intestate share is if the bulk of the estate is left to the omitted child's other parent, and there was at least one other child alive at execution of the will. That always confuses people, but think about it this way. The legislature wanted to make sure that we didn't just presume that because somebody was given the bulk of the estate that the testator intended that person to take care of the kids. So they made it very specific. They said if the other parent gets the bulk of the estate and there was already a child alive, then we're going to take that as evidence that the testator intended the other parent to take care of the children and trusted them to do that. That would mean that an omitted child would then be presumed to already be taken care of and would not get an intestate share. I hope this kind of slow, methodical thinking through of the hypothetical has helped you. As I said at the start, please let me know what else you think would help. What other kind of content could I provide that would be useful to you as you prepare for the bar or as you get ready for law school exams?